So the Labour Court has dismissed the SABC's application to reverse 28 irregular appointments at the corporation. Let's chat a bit more about that. Natasha Moni is a Labour law expert and she joins us here in the studio in Johannesburg. Natasha, thanks very much indeed for your time this evening. I mean, first of all, it doesn't seem like the judgment deals with what the SABC asked for in the first place. No, it basically said, go back and get your house in order.
That's basically what it said. But what happened is significant for all the state-owned enterprises, or all the enterprises that believe that they cover the public, they have public powers, because there have been a lot of decisions that have been made that were unlawful. And now the SABC wants to make those unlawful decisions invalid and irregular. And the court said you can't do that, because even though you belong to the state in some form or another, you actually are your own company. And an employer must be guided by the Labour Relations Act. If you have made if you have employed somebody that has been employed in the wrong manner, then you need to review your policies and you need to review the position. So either you retrench that person, or you place that person under some work performance management if that person is not performing. Also, the court said, Griselda, that it's taken the SABC a very long time to come to court to try and overturn all these appointments. These appointments were made under the cloudy regime. That was a very long time ago in terms of employment. And what have these people done wrong? They didn't employ themselves. What have these people done wrong in the interim for the SABC to want to undo what has been done?
Does this then speak to the SABC's own recruitment processes and lack of certain measures, tightening measures that should be put in place? Because in order then for this to have happened under the regime of Hlaudi Motsoeneng, it clearly then indicates that there's probably something wrong within the SABC's recruitment structure, for example.
Not necessarily. Someone enabled or facilitated the hiring of these people. It's not only Hlaudi Motsoeneng. Maybe he had an entire HR department that was enabling and facilitating the incorrect policies. Your policies are there, they're written, but it didn't mean that the HR department or the IR department stuck to them when these certain individuals were being enlisted or headhunted to come and assist the SABC.
By that, do you mean, when I talk about recruitment policies, I'm talking about human resources, for example.
Yes.
Should they have applied better scrutiny when these individuals were being given these jobs?
Well, that's exactly what they asked the Labour Court to do. Yeah. So they are saying, in effect, that they didn't apply the correct scrutiny and they didn't do their job. And that's why they want the appointment of these 26 or 28 employees to be overturned. So they're in themselves agreeing that they did not do things as tightly as they could have.
When I spoke to you a bit earlier on, you did say that perhaps the SABC could have handled this matter internally at a much earlier stage. What did you mean by that? That it should perhaps not have gone this far to court?
Well, this is exactly what the court said. The court said, look, we don't mind you coming to us, because it seems as that everybody, especially when the Zondo Commission is looking at all these state-owned enterprises and state capture, everybody seems to be running to the courts to overturn irregular appointments. That's all very well and fine, but you have an employment relationship with them. So you shouldn't have come on the basis of a legality review, for instance. You should have come to the SABC in another forum. And when I say in another forum, I mean if these employees, and they're your employees, if these employees are misconducting themselves, or they're poorly performing, or there is no longer a position for them, they've become redundant, then you go the operational requirements route, retrenchment, or you manage them in terms of poor performance and then have a disciplinary inquiry and then dismiss them in that route. You cannot get rid of your employees in a manner where you say, well, our contract with you is unlawful and irregular.
So what does this mean for the 28 employees?
They must come back to work. They must come back to work and show the SABC that even though their appointment may have been irregular, that they actually can do the job that they have been doing for the last couple of years.
and for the SABC, of course, to tighten its processes inside?
Absolutely. We don't know yet if the SABC is going to appeal this process. But the caution here is if they appeal this, they are now the guinea pig. If they appeal this process and they lose, it has so much effect on the employment relationship at the SABC and for the rest of the state-owned enterprises.
Yeah.
So I would always keep things internally. I would always look at my policies and my procedures and try and correct that there. After all, these people didn't employ themselves. They were employed by the SABC.
Natasha, I'm afraid that's all we have time for this evening. Thank you very much indeed for your time. Natasha Moni, who's a labour law expert, of course, on the labour law dismissing the SABC's application to reverse irregular appointments at the corporation. Let's take a short break now here on The Full View. Much more coming up after that.